I hope everybody's enjoying the holidays. In Northwest Arkansas, it's really cold. Okay, I see it's 1 o'clock. Welcome. We have wonderful presenters today. Um, Welcome to the Veterans Legal Assistance CLE. My name is Edith Chavez de Oseguera. I am the Program Coordinator for Arkansas Access to Justice. With this CLE, we wanted to commemorate Veterans Day by offering a CLE that was related to legal services and veterans' rights. Before I start introducing our three wonderful presenters, I wanted to give you a few announcements. For attorneys that are seeking CLE credit, I'll send the certificates of attendance in a link of this recording and the materials. I have three presenters today. Rebecca Feldman. Rebecca is the director and assistant professors of the Veteran Legal Services Clinic at the William H. Bowen School of Law. In her clinic, students provide legal representation to veterans in adjudications involving disability benefits and reconsideration of discharge status. Professor Feldman is passionate about helping students develop into reflective lawyers who are committed to using their skills in the service of the community. She began her legal career as an attorney at Legal Services of Eastern Missouri, where she represented low-income immigrants and their U.S. citizen family members in a variety of immigration proceedings. Before joining the Bowen faculty, Professor Feldman held clinical teaching positions at Villanova, Stetson Hall, and Georgetown, where she supervised students representing survivors of trauma and administrative proceedings. Her teachings center on trauma-informed advocacy and access to justice. Thank you, Professor Feldman, for being here today. Our next presenter is Cheyenne Pierce. Cheyenne is a special project and public benefits staff attorney at the Center for Arkansas Legal Services. Cheyenne has previous experience in criminal law and family law, where she also graduated with a bachelor's degree from the University of Nebraska and her JD from the William H. Bowen School of Law. Her work focuses on veterans, state planning, record sealing, and public benefits. Our next presenter is Lieutenant Richmond. He grew up in rural Sharp County, where he attended school before leaving for college. Lieutenant Richmond graduated cum laude from the Arkansas State University with a double major in finance and marketing. And not wanting to do either of those, he ventured into law. He attended the William H. Bowen School of Law, where he graduated magna cum laude. He has worked as a municipal law attorney for 7 years. And during this time, he has served also as a judge advocate at the Arkansas National Guard. This year, Lieutenant Richmond accepted a full-time position as an attorney advisor at Camp Robinson, and he now lives in North Little Rock with his wife and 3 dogs. Again, thank you, Rebecca, Lanny, Cheyenne, for joining us today and accepting this invitation. I'll allow now, Rebecca, the microphone is all yours, and we can get started.
Okay. Well, thank you, Edith. And I'll start by thanking you and Arkansas Access to Justice for hosting this CLE. I'm excited to be here today. I'm excited to hear Cheyenne's and Lieutenant Richmond's presentations as well. I'm going to start us off by sharing my screen. So give me just a moment to do that.
And during this time, I would like just to tell the audience, if you have a question during the presentation, please put that question in the chat. I'll be monitoring the chat and I'll be able to raise these questions at the end of each segment.
Thank you. Can you all see the PowerPoint? Great. So we'll go ahead and get started. So during my segment, I'm going to talk about navigating the VA claims and appeals process. As Edith mentions, that this is a key part of our work in the Veterans Legal Services Clinic, but we also have a program that works with volunteers, and we would love, as a result of this CLE today, to get more volunteers to work with our program. So as Edith mentioned, I direct our in-house clinic, but we also have a pro bono program that is directed by Zach Baumgarten. And so we are able to provide referrals to veterans who we aren't able to assist in-house in the clinic, and we help with a wide variety of things. So if you're interested in doing VA work, we would love to have you. We have mentor attorneys that can help you out if you're new to this area. But we also need volunteers in any other area of law. We get veterans calling us on lots of different issues, whether it's related to housing, other consumer issues. We would love to have you help us no matter what your area of practice is. And so I'll tell you a little bit more at the end about how to volunteer with us. So today, this is going to be just a big picture overview. We could probably easily spend a whole day or a half day CLE on this topic, but I'm not going to do that to you. We're only going to breeze through the basics. So I'm going to start by talking a little bit about the VA claims process. Then we're going to move into the two different systems of VA claims, the old system, which is called the legacy system, and the newer system, which is called the AMA, or the modernized system. Then we'll go into how do you decide between your different options in the AMA, and then we'll talk a little bit about appeals to within the agency through the Board of Veterans Appeals, and then up to the Veterans Court, the Court of Appeals for Veterans Claims, or CAVIC. So to start with an overview of the claims process, first of all, I want to mention that if you are going to work with veterans and representing them before the VA, you must be accredited by the VA. But don't be intimidated by that process. The process of being VA accredited is actually pretty straightforward. There's a very, very short form that you have to fill out. You have to be in good standing and licensed in at least one state. You have to report to the VA every place that you are licensed to practice, and then they'll do a background check. And then once you clear the background check, then you are VA accredited. Within your first year of becoming VA accredited, there is specific requirements about the CLE that you have to do. You have to attend a 3-hour CLE within the first year after you get accredited, and then additional 3 hours every 2 years after that. And then every year you have to certify to the VA that you're still in good standing in the states where you're licensed to practice. We have law students working in the clinic because law students under the VA regulations are allowed to represent veterans as long as they're doing so under the supervision of a VA accredited attorney. And then if you are representing someone with the VA, you have the key forms down here that you have to file to notify VA that you are representing a veteran. So big picture here, the structure of the VA that we're working with is within the VA Office of the Secretary, there are 3 different administrations. There's the Veterans Health Administration, which, as you might assume, administers the VA hospitals. There's the Veterans Benefits Administration, which is the part of the agency that we'll largely be focusing on today. And then there is the National Cemetery Administration. There is often confusion among veterans and among attorneys about the difference between the VHA and the VBA, right? And so you cannot assume that what's going on the veterans healthcare side of things is automatically known by the VBA or vice versa. So we'll talk a little bit about the VA's duty to assist and how the VBA should be getting records from the VHA. But that is one area of confusion. The VHA and the VBA are not the same entity. They have different purposes. And then if we're talking about appeals from the VBA, appeals from a compensation claim or a pension claim, then that would go up to the next level of administrative appeal is the Board of Veterans Appeals. So the first step that the VA is going to look at when they're trying to determine whether someone is eligible for compensation or any other VA benefit is they're going to look at whether that person is a veteran. And VA has a unique definition of veteran. It does not mean just anybody who has served in the military. So we at the clinic use the definition of anyone who has served in the military, we consider for our clinic purposes to be a veteran, but the VA does not have that same definition. So you have on your screen here the references to the US Code and the provisions of the Code of Federal Regulations that define who is a veteran for VA purposes. And there's basically 3 questions that you're asking here. The first question is whether that person had military service, right? Military, naval, or air service. And then whether that service was active. And then finally, whether the discharge involved dishonorable conditions. And this is another point of confusion. And so we'll try to be clear on this, but if you've got questions, please feel free to ask them. VA's definition of discharge under conditions other than dishonorable, that does not mean the same thing as an other than dishonorable discharge by the Department of Defense. So if someone has an other than honorable discharge, for example, they may or may not be eligible for VA benefits, depending on whether one of the bars that's in the VA regulations applies to them. So if someone has an honorable discharge, or they are eligible for pretty much all VA benefits. If someone has a general discharge from the DoD, they are eligible for most VA benefits, but note there's an exception for VA education benefits there. If they have an other than honorable discharge, they're going to need the VA to go through what is known as the character of discharge determination process. And we'll talk a little bit more about that in a minute here. And then bad conduct and dishonorable discharges generally are not going to be eligible for education, disability, and other benefits unless you can show that there is an exception that applies. It is called the insanity exception. The VA has a very unique definition of insanity. It's not the same as what that is defined as under criminal law. So generally, if you have a veteran with one of those discharge statuses, you're going to want to dig a little bit deeper into what are the potential VA bars to benefits that might apply, and is there a way of overcoming them? And that, again, could be a separate CLE, but I'm happy to answer questions about that if there are any. When we're talking about VA compensation, we have basically 3 requirements here. First of all, the purpose of VA compensation, as the name might suggest, is to compensate for something that happened in service that caused long-term injury to the veteran or that aggravated a pre-existing condition. So there has to be, the veteran has to have a current disability or a disease. That requirement relates to some sort of functional impairment of some part of your body, including your mind. And then there has to be an in-service event, injury, or disease. And then you have to show a link between the current disability and what happened to that veteran in service. Big picture overview of how a claim goes through the VA. It'll start off at a VA regional office, which you might hear referred to as a VERO or as an AOJ, which is also stands for an Agency of Original Jurisdiction. If a claim gets denied there, the veteran has a right to take it up on appeal, and the AMA has several different routes of appeal, but one of those routes of appeal is to the Board of Veterans Appeals, the BVA or the board. If the board denies the claim, then the veteran has the right to take the case up to the Court of Appeals for Veterans Claims, or CAVIC. And then beyond CAVIC, the appeal levels are up to the Federal Circuit and then the Supreme Court of the United States. We've got some basic forms here that you'll want to look at if you're helping a veteran who maybe your veteran has already filed a claim. Maybe they've gone to a VSO for assistance with a claim, or maybe they're coming to you in the first instance for help. But the first form that is going to be filed to get the process started is called the intent to file. That's the VA form 210966. If your veteran hasn't filed a claim, it's important to try to file that form as early as possible, because that will preserve your filing date, which is known as an effective date in VA world. That effective date is important because that is what the VA uses to calculate how much compensation is owed to the veteran. So the earlier you can file that form, the earlier you can establish the effective date of the claim. And then you have 1 year from filing of the intent to file to file the actual substantive claim application, which in the case of compensation is the VA 21526 EZ. So again, it's important to make sure that if you do the intent to file, make sure that 21526 EZ is filed within a year. Otherwise, you lose the effective date. And then the effective date would be the date that the 21526 EZ is filed. And note too that the date of the claim is the date that VA actually receives it. It's not the date that it's mailed or sent by the veteran. The good thing is that VA does have a way of electronically filing these forms, so you can get them filed pretty easily. they use Quick Submit to file these forms. And then you also have a couple other key forms that you'll want to look for in the file, including if the veteran is applying for PTSD, there's a specific form, the 210781, that they can use to explain what happened, explain the stressor event, explain how it impacted them, explain their diagnosis of PTSD. And then if it's not a case involving PTSD, there's a separate form, the 214138, which the veteran can use to give their statement. And the VA also has a document evidence submission form, which you can use to describe other types of evidence that you are submitting. The VA system, as some of you might know, is unique in that the standard of proof is favorable to the claimant. So the standard is the benefit of the doubt. And that's, as you know, that's unique in the legal world, right? This is because the VA is supposed to be a pro-claimant system. That means that when the evidence is in relative equipoise, the claim is supposed to be granted. The veteran is supposed to get the benefit of the doubt. So if there's an approximate balance of positive and negative evidence, then the claim should be granted. And so this is one of the unique, this is sometimes also expressed as that it's as likely as not that the veteran is entitled to the benefit that they're seeking. One of the other unique aspects of the VA is that it's referred to as paternalistic as well as proclaimant. And paternalistic means that the VA has a duty to assist the veteran. So when VA gets a claim, these are the different steps that they go through in making a decision on that claim. They will start by doing the character of discharge determination, right? That's the process that allows them to see, does that person meet the definition of a veteran? And if so, then they'll move to the next step of the process, which is their duty to assist kicks in. So the VA, I would not recommend relying solely on the duty to assist. The more evidence you can gather in support of the veteran's claim before you file, the easier you're going to make it on VA to grant that claim. But the VA does have a duty to assist the veteran by obtaining certain records that might be in federal custody, and by providing a medical examination or medical opinion if the evidence submitted is not sufficient to decide the claim. So that examination is referred to as a CNP exam, is short for compensation and pension exam. And that should be requested when there's not enough evidence to decide the claim, but there is competent lay or medical evidence of a current disability or persistent recurrent symptoms of a disability, and the veteran suffered an in-service event or injury, an indication that the diagnosis or symptoms may be associated with something that happened in the service. So then after the VA completes its duty to assist, obtains any records that are reasonably available to it and the veteran has requested the VA to obtain, then they'll look at the evidence and determine whether those three elements for compensation are met. And if service connection is established, then they will determine the severity of the disability using their rating schedule. And the rating schedule, as you'll see here, is set out at 38 CFR section 4.1 and following sections. And then they set the effective date and award compensation. So the next part of this presentation is going to talk briefly about legacy appeals versus modernized appeals. So basically, Congress did an overhaul of the VA system which was signed into law in 2017, and that is known as the modernized system or the AMA system. The system prior to that is now known as the legacy system. So legacy applies to decisions that are dated before February 19th of 2019. Veterans could opt into the new system if they were in the legacy system in some cases, and we'll talk more about that. And then the AMA or the modernized system applies to all new claims and decisions that were on or after February 19th of 2019. So I know 2019 was several years ago. You might be wondering, why do I need to know about the legacy appeals process if a veteran is coming to me for help? Well, these cases can go on for years. So you need to know about legacy and the modernized system, because some veterans had claims in the legacy process. Some claims might be still have documents from that process. So you'll want to know how to recognize the history of the claim, and that's where the legacy process comes into play. This also helps you understand whether a claim has been continuously pursued. So in the legacy process, you see sort of a pretty relatively straightforward timeline here, right? And so the timeline starts with the rating decision by the VARO or the AOJ after the veterans has filed the claim and the claim has been adjudicated. If that decision was unfavorable to the veteran, they would file what was called a notice of a disagreement. You have the form number on your screen. And then after that notice of disagreement, the VARO issues what was called a statement of the case, or the SOC. And the statement of the case provided a more detailed explanation, provided the relevant law, provided the relevant facts related to the decision, provided the evidence that the VA was relying on to explain their denial. So after you get the SOC, the veteran then had 60 days to file the substantive appeal to the Board of Veterans' Appeals. So this part of the process, from the time of the rating decision to the time of being able to file the appeal with the BVA, in some cases went on more than a year. And you basically had to take 2 steps before you could get the case to the Board of Veterans' Appeals. It's also worth noting that in fiscal year 2016, about 87% of cases were remanded by the BVA, not flat out reversed. So you would go through this process and then get sent back to the VARO and then have additional proceedings going on. So when AMA came around, the process was to try to simplify this process rather than having 2 steps, making it simpler to get to the BVA, but also provide the veteran more options for appeals because there were huge backlogs at the board. So this is what the AMA appeals process looks like, right? This is interesting to me because it doesn't look simpler, right? Even though it was supposed to simplify the process. But it does provide the veteran more options. And so the 2 new options that were presented that we'll talk about a little bit later were this higher level review and the supplemental claim. And these were intended to, and actually are, moving much more quickly than board decisions. The problem is that the higher level reviews, sometimes they still don't get it right. Sometimes they're not the best option for more complex legal issues. And so you might still see cases going up to the board, just having additional adjudications along the way. But the nice thing here is that you see there's the 1 step, right? So you get the VBA decision. It's supposed to have improved notice, although the decisions often are not quite as long as the statements of the case used to be. But they are required to have favorable findings in them. And so if a decision does not have favorable findings under the AMA, that is automatically a basis for appeal. And we'll talk more about these different options later. But basically, you have 1 year to select one of these options. And assuming you file the claim within 1 year, it'll be continuously pursued. So if you could file a supplemental claim, and if that gets denied, you could do a higher level review. And if that gets denied, you could do an appeal to the board. And then you still have this right, still have the right to appeal to the Court of Appeals for Veterans Claims from the board within 120 days of a board decision. So let's talk just a little bit about an example of this. I know we don't have the ability to sort of chat here, but just think about this answer and then write it down on your own, and I'll tell you what the answer is here in a minute. So assume you have a new client, GI Jane, who filed her initial claim for service connection for PTSD and knee pain on March 30th of 2018. The VA denied her claim in a decision dated September 18th, 2018. And then she timely filed a form 210958 to contest the denial. Then on December 1st of 2018, the Vero issued a statement of the case detailing the reasons for its denial. So at this stage of the case, you see this in Jane's records. You're going to be asking yourself, what appeal system does Jane's claim appear to be in? Is it a legacy or is it an AMA case? And then if Jane had wanted to appeal her case to the BVA, what form should she have filed next and by what date? I'll give you just a couple seconds to think about that. So Jane's claim seems to be in the legacy system based on these facts, but there might be more facts that we want to know. So we can tell it's in the legacy because we've got a form 210958 in her file, and we've got a statement of the case, right? So the modernized system, you wouldn't see those two forms. If she had wanted to appeal to the board, she would have had to have filed a VA Form 9 within 60 days of the statement of the case. So by January 30th of 2019. But here's the caveat. She could have opted into the modernized system because the notice of the NOD was filed. So if she wanted to opt into the modernized system, we would have some more questions for her about what happened next. Did she file anything? If so, what did she file? And so we'd be looking at the Rapid Appeals Modernization Program. So this was launched in November 2017. It allowed veterans to opt into the new system out of the legacy system between April 2018 and February 15, 2019. As long as you had an appeal pending in one of these stages. So if you had a notice of disagreement filed, which Jane did, or if you had filed a Form 9 to the BVA, or if it had been certified to the board but not yet activated for decision, or if you had a remand from the board to the Vero. And so if you had wanted to know whether if you have Jane's file, you wanted to know whether or not she was in that system, you would be looking for this form in her file. So this is the RAMP opt-in election form. She would have had to select one of these options. And so this is what you would be looking at to determine whether that happened or not. Okay. So to get into a little more detail about which lane do we want to pick, we know we've got different options in the AMA. And so this is a little bit more about the different options in the AMA. The supplemental claim option exists still within the VBA. It requires the veteran to present new and relevant evidence. That standard is important because that was designed to be a looser standard than under the legacy system. Under legacy, if you wanted to have a supplemental claim, you had to have new and material evidence. And then with a supplemental claim, the VA's duty to assist kicks in. Like all of these, you have a year to file if that supplemental claim is denied. And you can appeal a supplemental claim either by a higher level review, a board appeal, or another supplemental claim. And as long as you do one of those within a year, you're going to preserve that effective date. This says it's the quickest of the 3 lanes. I think there's a little bit that's not necessarily still true. I think higher level reviews might be a little bit quicker right now, but there's similar timelines between the supplemental claim and the higher level review, depending on the case. The higher level review is then sort of an appealing within the V. It's you can think of it like supervisory review, essentially. There's a closed record. You don't get to present new evidence. The duty to assist does not kick in. You do have an option for a one-time telephonic informal conference with the interviewer. So if you want to present oral arguments, essentially, you could do that with the higher level review. The higher level reviewer, like the board, is going to take a de novo review of the case. And then you have a year to file another appeal if the higher level review gets denied. So you can't do a higher level review of a higher level review, but you can do a supplemental claim after a higher level review, or you can go to the board after a higher level review denial. And then the Board of Veterans Appeals or Board Appeal goes up that level higher. So it gets out of the Office of the Secretary, it goes to the Board of Veterans Appeals, which is the administrative appeal within the agency. There's basically 3 dockets that you can choose from. The direct docket is the fastest of those options. It's a closed record. You don't get a hearing, so that's why it's the fastest. There's the evidence docket, which allows you to present new evidence within 90 days of filing your appeal, but you don't get a hearing on that docket. And then there's the hearing docket, which, as its name suggests, you get to have a hearing before a veterans law judge. You can submit additional evidence at the hearing or within 30 days after the hearing, but that is the slowest of the 3 lanes at the board. And we'll talk a little bit more about timelines here. So according to the VA's metrics, the supplemental claims currently, as of October, are taking around 158 days to decide. The higher level reviews are taking around 94 days to decide. And all of the board lanes are taking more than a year. I think some of these, based on experience, some of these times at the board seem to be optimistic, to say the least, especially the hearing lane. The hearing lane, the official reports say that that's 708 days to completion. According to some other various listservs and other practitioners' experience, it actually seems right now that those rates are closer to, they're currently taking about 4 years to adjudicate on hearings. So they're currently scheduling hearings for claims that were docketed in April to May of 2020. But just to talk a little bit more about this has slowed down since the AMA was first implemented. But there are pros and cons to each of these lanes. So as of, I think this was around July of 2023, the higher level reviews had about a 45% grant rate. That includes about 11% that were completely overturned, and then about 35% that were returned for correction of an error. And they're pretty good at sticking to the 125-day timeline. If you go up to the board, if we're talking about direct review, they had about a 26% grant rate and about a 38% remand rate. So that's pretty good. There's some questions about, there was a hearing yesterday about the quality of board decision making, which if you're interested, I can share that link. There's a news article about that as well. The evidence submission lane, according to the VA's metrics, had about a 29% grant rate and a 41% remand rate. So when you're submitting additional evidence, the likelihood of the claim being granted or remanded gets a little bit higher. So that was a slightly lower denial rate in the evidence lane. And you have the best chance of success in the hearing lane, although that is the slowest of the lanes at the board. The hearing lane has about a 29% grant rate and about a 38% remand rate. So only about 14% of cases that have a board hearing are denied. Duty to assist errors are actually a common reason for remands at the VA. And this is, you might find this number a little surprising. Again, this is taken from the VA's own metrics, but of the claims that go to a higher level review, in fiscal year 2023, 317,799 found duty to assist errors. And the vast majority of those, a little over 220,000 of those, related to errors involving the CMP examination and the medical examination. So the supplemental claim, pros and cons of doing this lane. The pros are you can address duty to assist errors earlier. It's a faster timeline than the BVA dockets, and it allows earlier consideration of new evidence. But some things to be aware of is that the VA might determine that evidence is not new and relevant. There's a high likelihood that a new CNP exam will be ordered, which might not be the best thing for the veteran if there's already medical evidence that would allow the VA to grant the claim. And the VA could misconstrue it as a new claim and therefore set the wrong effective date. Although in our experience, this is happening less and less frequently as adjudicators get more familiar with the AMA system. Pros and cons of the higher level review: it can be a fast way to resolve clear error, and the duty to assist does not apply. And it could be a strategic move if you think there might be additional evidence, or you just want the VA to add more detail to its explanation of its findings on the claim. It's not a great option for more complicated legal arguments, though, and the current rate is comparable to the other lanes. And again, the board appeal, pros and cons. Pro is that you got an attorney, someone with legal expertise reviewing the case. The evidence docket bypasses the duty to assist. So if you've already got sufficient evidence, that can be a quick way of resolving if you've got a legal issue in the case. The hearing docket gives the veteran the opportunity to speak to an administrative law judge. And there are more lenient guidelines for advancement, but you can expect to wait more than 1.5 years on all the dockets. So that's the biggest con of taking a claim up to the board. So we're going to spend a little bit of time just testing your knowledge here. And again, I'll give you just a few seconds to answer this question. I'll read through the fact pattern and the questions. We're going back to Jane's file. And so you see that she opted into RAMP and selected the supplemental claim lane. She submitted a letter from her doctor and a buddy statement, and the VA denied her claim again on May 16th of 2020, claiming that she did not have sufficient evidence of service connection. Jane gathered additional evidence and then filed another supplemental claim on December 15th of 2022. VA denied her claim again and said that while new, the evidence she submitted was not material to her claim. And the VARO reached its decision on June 25th of 2023. So based on these facts alone, we want to know, has the VA made any appealable error? If so, what was it? At this point, which AMA lane would you recommend and why? And what is the appeal deadline? And then assuming Jane files an appeal of the June 2023 decision and wins it, what will be the effective date of her claim? I'll give just a few seconds to think through that. So if you're still working through it, that's okay. I'm going to go ahead and talk through the answers because I know we're sort of short on time for this portion. The VA has made an error based on these facts alone, and that is that she's in the AMA, so they used the wrong standard. So they claimed that she needed new and material evidence. She actually only needed new and relevant evidence. So that is an appealable error. Because that's a relatively simple legal issue, you could file a higher level review. This second question is sort of harder to answer, right? Because we would want to know a little bit more about Jane's case. We would want to know what other evidence already existed. Is filing additional evidence likely to help Jane or not? But you might file a high level review just to get clarity on the question related to the wrong legal standard. You might also talk to Jane about getting additional evidence. And if that were the case, you would think about doing either a supplemental claim or one of the lanes at the board that allows you to file new evidence. But the appeal deadline for that would be in June of 1 year from the decision, so on June 25th of 2024. And then assuming that Jane timely files an appeal, the effective date of her claim would be December 15th of 2022. Note that it wouldn't go all the way back to when she initially filed her claim because she waited more than a year between the 2020 decision and when she filed her supplemental claim. So the effective date would only go back to that December 15th 2022 supplemental claim. We're going to talk just briefly about BVA proceedings as the next step of appeal, and Court of Appeals for Veterans Claims decisions, just to give some background knowledge here. BVA cases are heard by a single judge. The board itself is located in Washington, D.C., but they conduct teleconferenced hearings. So the veteran can testify from your office or from their own home. And in AMA claims, favorable findings are binding on the board. It's also worth noting that only the veteran can appeal to the board, right? So if there's a positive decision for the veteran at the VERA level, the VA doesn't get to appeal that. That is the decision on the case. And we had the Court of Appeals for Veterans Claims. It's worth noting that that court did not exist before 1988. So before 1988, BVA decisions were not subject to judicial review. And so there's a real opportunity, an ongoing opportunity for attorneys to have a positive impact by helping veterans at the Court of Appeals level, because the case law is relatively new and still evolving. We've got a little bit of background here about who the board judges are. I'm going to sort of go through this relatively quickly to get to our next presenters, but the chairman's annual report to Congress is available online. It's worth a read if you're wondering more about board practice. And then when we're talking about the Court of Appeals for Veterans Claims, attorneys must be admitted to the court's bar. That is in accordance with Rule 46 of the court's rules of practice and procedure. You have to file a notice of appearance in each case, and law students may appear before the court subject to Rule 46. We've got just a quick comparison here of the scope of review between the board and the court. So the board is an administrative agency. It's the highest level of review within the VA. It is not adversarial. There's no opposing counsel at the board. And you may submit new evidence depending on the lane. CAVIC is an Article 1 court. It's not an Article 3 court. So, but it is similar to Article 3 courts in that it is adversarial. The VA is represented by counsel at CAVIC hearings, and the veteran is may be represented by counsel. And review is limited to the record before the VA, known as the RBA, the record before the agency. Its scope of review is set forth at 38 USC 7261. Those of you who are familiar with administrative law will see that this looks very familiar to you, right? Because the scope of review very much mirrors the Administrative Procedures Act, or the APA. And so this CAVIC will review for findings of fact to see if they were clearly erroneous. They'll review findings of law de novo, and application of law to fact is reviewed to see if the decisions were arbitrary and capricious. I want to put a quick plug in for the Veterans Consortium. This is a wonderful organization that allows pro se veterans to request help from attorneys nationwide who have volunteered to help through the TVC. CAVIC helped create the TVC's pro bono program due to concern about the number of unrepresented veterans when the court first started. And the Veterans Consortium screens cases, trains volunteer attorneys, and pairs veterans with volunteers. So if you're new to this area of law, the Veterans Consortium can be a really helpful way of learning more because you're paired with a mentor. They screen for different levels of difficulty. And so this is an easy way to get involved in a case and learn a little bit more about veterans law while helping a veteran through this process. And so I would encourage you all to look into this if you are interested, and especially if you do appellate work. You can also get, if you're successful in the case, you can get attorney's fees if you win your CAVIC case as well. I don't know if we've got time for questions, but if folks have any, they can put them in the chat. We've also got a few resources here if you're interested in learning more. And then I would encourage you to follow us and to feel free to volunteer with us. We would love to have more volunteers if you're interested in working on a VA compensation case, or like I said earlier, if you just are interested in helping veterans on areas that are already within your wheelhouse, within your area of expertise, please volunteer with us. And you've got my contact information as well, so please feel free to contact me afterwards if you have any additional questions. And so with that, I will turn it back over to Edith.
Thank you so much, Rebecca. Well, it was super informative. I don't believe that the audience has any questions, but I do have 3 questions for you. Just to clarify, is there an income threshold to qualify for services with your clinic?
There is not, no. So we try to fill the gap in access to justice for folks who are just slightly over income for CALS, but still living in poverty. But we don't have any strict income requirements.
Perfect, thank you. And another question is, what conditions generally qualify for VA disability under the rating system? Is there a way to know in general terms what could qualify?
So yeah, so if you look at the rating schedule at 38 CFR Part 4, that will go through each of the different, it goes basically through all the different body systems, and you can see how the VA rates disabilities and based on what part of the body is affected.
Perfect. And lastly, I know you left your contact information, but is there a form that volunteer attorneys have to fill out or a link?
So if you go to that, the link that's in the QR code, that gives you the form that you can fill out to volunteer with us.
Perfect. And we'll share that link also on that email once I send those certificates of attendance. Thank you so much, Rebecca. Now we give room for Cheyenne. Thank you.
Thanks.
Thank you, Edith. Let me share my screen. Looks a little bit different than practice, but can you see it?
Yes, we can see it.
There
Perfect.
we go. So first, I just want to say thank you, Edith, for having us today and being able to speak a little bit about our services here at CALS. My name is Cheyenne Pierce. I'm a staff attorney here with CALS. I've been here for about 1.5 years, or a little over 1.5 years. And today I'm going to talk to you guys a little bit about our services here at CALS, some veteran-specific services that we offer, and then how you guys can get plugged in with us. Okay, so who are we? The Center for Arkansas Legal Services, or CALS, is a nonprofit. We offer free civil legal aid to low-income Arkansans. We serve 44 counties here in Arkansas. This is shown by the blue color or the teal color here on the map. And then that orange color is Legal Aid of Arkansas. And so together with Legal Aid of Arkansas, we cover the entire state. We have offices in Little Rock, Hot Springs, Pine Bluff, Fort Smith, El Dorado, Rogers, and Russellville. So we're kind of pretty spread out across the state. You can see that by the stars here on the map. We offer online services at our website at arkansaslegal.org. So at our website, I'll talk a little bit more about it in a later slide, but we have fact sheets on there, pro se documents that individuals are more than welcome to fill out and use. There are blog posts. There's information about upcoming clinics that we do, and lots more information on there. And then this is our helpline number. This number is the number that individuals can call to apply for services and speak with someone. It's also the number that you guys can call and just try to get in contact with one of us here at CALS. And so the services that we offer, just civil legal aid, but we don't do all civil areas. And so the areas that we focus on are housing, family law, consumer, disaster relief. We do criminal record sealing, consumer, debt and bankruptcy, estate planning or end-of-life planning, some administrative law, public benefits, SUD and OUD, and then veterans law. So the 2 big questions that we probably get asked the most are if we do criminal and if we do personal injury, and we don't do those 2. So a little bit more in depth of kind of the cases that we see for housing law are landlord and tenant issues, rent to own or contracts for deed, foreclosure, tenants in foreclosure, and public housing. I would say for veterans, this is an area that we see a lot is housing law, and it's going to be like HUD vash, evictions, and landlord and tenant issues. And then for our family law, we primarily see divorces and guardianship cases. We also do orders of protection and child support. I would also say that family law is a pretty big area for veterans that we see. Some just need a divorce, some child support issues, and guardianships. Power of attorneys will also kind of fall under this as well. But yeah, I would say divorces and guardianships. So family law and housing are two of the bigger areas that we see veterans having issues with that come to us for. And then our consumer protection department focuses on used car sales, scams, debt collection, and bankruptcy. This is also an area that we see for veterans as well, but it's just not as big as some of the other ones. And then our public benefits division focuses on SSD and SSI, Medicaid, food stamps, and Arkansas Works. In this division, we also do record sealing. We do record sealing across the board, but this is the division that houses our record sealing department, as well as veterans law and our administrative law issues. And estate planning, almost forgot. Okay, so the types of services that we offer. So we offer advice to full representation. We don't do full representation for every client that we see. And some people just need a consult. So I would say our helpline services and some of our clinic levels is where we give those consults at. We also research legal issues for them and brief issues. So if someone comes in and they have an issue that needs a little bit more research, and maybe they need the proper, direction for after that issue gets some research, we'll do that for them. We do limited scope services. So this could be drafting and providing pro se docs to them. It could be drafting a beneficiary deed, a will, divorce complaints if it's a simple divorce. Any petitions really are answers. Petitions to seal. Sometimes people they want to do it themselves, but they don't know how to fill out the petition. So that's things that we will do for them. And then, of course, full representation. So that advice level all the way through. We also offer our services online. As I kind of previously mentioned, we have two websites. So our arkansaslegal.org website and then our arlawhelp.org website. On here, you'll find interactive forms. And there's also pro se forms as well as fact sheets. So there's a section on there for each of our different areas of law. And then it kind of breaks down into, more specific areas. So divorce, guardianships, power of attorneys, and etc. And there are also videos on there and blog walkthroughs for some of these processes. On our website, we also have our events and some updates in the law. And so you can just go on there to check that out as well. We also post on our social media platforms. Our communications department is really good about posting. And so if you follow them at Arkansas Legal, you will see what we are doing next and any upcoming clinics that you can send people to or get involved if you want to participate in them. Also, if you guys ever see, hey, this is something that we should have on our online or on our website, please feel free to reach out to us and we can look into it and see if we can't offer it. Okay, so how can we help? How can applicants apply for our services? They can call our helpline number from Monday through Friday at 9 to 3 p.m. When they call our helpline number, they speak to a live individual, so it's not an automatic system or anything. And then if their outside hours, they can apply online at arkansaslegal.org. And then online, it just is a little box that they fill out what their legal issue is, and then someone will get in contact with them. They can also come to an outreach event or to a clinic. Again, at these clinics, it's not just advice always. It can be us drafting a document for them or taking them back in-house for full representation. And then again, our free resources are online, those pro se docs. And then if they don't, if they are kind of reading it and see that they might need a little bit more help or assistance, or that they have questions, they are welcome and free to call us. Okay, so our veteran-specific services that we offer VLAPs monthly. So our VLAPs are our Veteran Legal Assistance Program. We partner with the Bowen Law School Veterans Clinic, and together we offer VLAPs twice a month. Our first one monthly is on the second Thursday of every month. It's in Pine Bluff at the new Veterans Center and Memorial. It's at 114 South State Street. And if you guys haven't been there, it is a nice new building. It houses their county VSO, and it's, I don't know, it's just really nice in there. Then our second one is the third Tuesday each month in Little Rock. It's at the Veterans Day Treatment Center, downtown at 1000 South Main Street. This one is pretty nice as well. A lot of individuals come to this one. They offer and serve them breakfast there. They also have caseworkers there, which is really nice and helpful to know, because their caseworkers, not all of them have caseworkers, but a lot of them do. And these caseworkers help them with different issues, like maybe applying for Social Security or pointing them in the right direction for certain issues. So that's really helpful and nice to know. They'll even help them with HUD-VASH vouchers as well. So it's just great to know if they have caseworkers there. We're also looking to expand our VLAPs. There's been some talk about adding one in Fort Smith. And so if you guys are thinking, hey, we could use one here, or maybe we could use the clinic here, please reach out to me and let me know. We'd be more than happy to look at how we could assist in that area. So a little bit continued. Our clinics are staffed by us here at CALS. And then, like I said, we partner with the Bowen Law School, the Veterans Clinic. And so Zach comes with us each month. And then we have law students who will come sometimes, as well as other pro bono attorneys. And I will say that having pro bono attorneys at our clinics is very helpful, because you guys might have expertise in a certain area that could assist our giving consults with veterans, and it's very helpful. Let's see. So each of our clinic assists approximately 20 to 25 veterans. Sometimes it's less, sometimes it's more. It just kind of depends on how many come to our clinics. Our clinics are also each month from 9 to 11. So it's 2 hours, but a lot of times it'll go over. It just depends on the number of individuals that we see. So again, they're given fact sheets, or they're just able to come and consult with us and speak to us about what's going on, what legal issue they might have. And if it's something that we don't do, we try to point them in the right direction, or say, hey, do you have a caseworker here? Or, you know, try to figure out what's going on and how we can assist them. Some just come in there looking for advice, or they just want to talk and let us know what's going on. Others want documents drafted, or maybe it's something that we can't do there, and so we take it back in-house for full representation, or maybe we take it back just to research. So it's not always just giving advice to them. We try to get them situated with what we can. Yeah, so that's kind of there. I will say, if you guys volunteer as a pro bono attorney, don't think that you have to take cases back in-house. You can just simply come to a VLAP and just provide advice, and you don't have to come to every one of them. I think some people get scared that they're going to take all these cases back in-house, and that's not the case. You can volunteer or participate as how much little you want to. Okay. So legal issues that we see for our veterans, as I kind of mentioned, for veterans, it's kind of all across the board. I would say that family law, record sealing, and housing are probably the biggest areas that we see our veterans needing assistance in. We also offer discharge upgrades, veterans appeals, and then some other VA-related legal issues like overpayments. We've had some nursing home where the VA pays for a specific nursing home issues. So just stuff like that. If you think that it might be something that we would do and you're having or know of someone coming to you, just send them our way and we can see if we can't assist them or we'll send them in the right direction. I also want to mention that they do not have to wait to come to a legal clinic to receive our services. I think that's been a big thing, is that people say, oh, you can just go next month. But they can just call our helpline, or if you want to send direct referrals to me, just let me know. My email will be up here at probably the end of the slides, or I can give you guys my contact information. But just reach out to me. Otherwise, they can contact us through our helpline number or online as well. So I also want to mention that we recently received a homeless and at risk of homelessness grant. And this grant has allowed us to be able to further assist veterans who are experiencing homelessness or who are at risk of homelessness. I do want to mention that this at-risk definition is pretty broad. And so again, if you are seeing individuals coming to you who you're like, I don't know, maybe they're at risk, just send them our way. We can better determine if they are or not. For this grant, we currently receive clients through direct referrals or through our outreach events, through our BLAPs. We're looking for more clients. We're looking to do outreach. So if you guys are seeing individuals, please send them our way. We also have 10% of this grant dedicated to women veterans. So if you are seeing women veterans or might know if they have legal issues, or maybe they have specific legal issues, like maybe they need a PowerPoint on orders of protection or something that we can offer to them, please reach out to me and let me know. Yes, and also I think I already mentioned, but again, if you would like a clinic or something in your area, we're open to ideas. Just let me know. So as Rebecca mentioned about pro bono attorneys, we're always looking for help. Again, I think it's important and it's nice for the community to be able to kind of give back and assist them in these areas. So again, there are different ways that you can assist us. You can volunteer at our VLAPs or any clinics really, but our VLAPs are twice a month. You don't have to volunteer for all of them, or you don't have to take clients back either. If you would like to volunteer with us, you can reach out to me and let me know, or you can sign up at arkansaslegal.org/pro bono. And then here is another slide. You can scan the QR code. I will mention that you can earn CLE credit for volunteering as a pro bono attorney. It's 1 credit hour for every 3 hours served, so up to 3 credit hours. And then that is all I have for you guys. If you have any questions, please feel free.
Thank you, Cheyenne. We do have some questions from the audience. Robert asks, does the debt portion of your services include credit reporting issues?
Credit reporting issues? I do not know that off the top of my head. I will have to ask our consumer department, and I can get back with you on that.
Okay, perfect. Robert, if you want to put your email address on the chat so that we can answer that question and follow up with that, please do so. And he has another question. What types of debt issues do you see most often?
We see some bankruptcy issues, and then I would say used cars or car sales we see come into the clinic. And that's about it from what I've seen the past few months for consumer.
Perfect. And last question, for volunteer attorneys who want to maybe help you with full representation, do you guys also provide mentorship?
Yeah, I mean, We can. I don't know how much we have done in the past, but we definitely can and are willing to assist in that.
Okay, that's great to know. Well, now we're up to, please, Lani, you can start your presentation. Thank you again, Cheyenne.
Thank you.
Yeah, I'll go ahead and jump in. Can everyone see my shared screen? Let's see, perfect. Getting some head nods. Yeah, so I should say I'm Lieutenant Lanny Richmond. I work out here full time at Camp Robinson for the Arkansas National Guard. One portion of what we do is we have an Office of Legal Assistance where we help virtually any service member, retiree, dependent, anyone with that military connection. They can come in and we'll do our best for them. There's some things we can't do, but we try and help everyone out. Even if you fall under the Department of Homeland Security or a Coastie, got our Coast Guard guys out there, we'll do our best for you. You can show up and we'll do our best, I promise. But our office, we've got 5 full-time employees. That's 3 attorneys, a legal assistant, and a paralegal out here. So we stay pretty busy just with, everything we try and do. So my full-time job, we do this, but then we also, help out with the Arkansas National Guard. That's, I think between 8 and 9,000 part-time military service members and well over 1,000 full-time people working to keep that operation going. So we're always busy. So much like everyone else, I'll give you our sales pitch. We have an attorney referral list where we can refer cases out that we can't help with, either because they're just too complex or it's something we're prohibited from doing. So I'd really encourage anyone out there, if you want to, just get on that list. And again, this isn't pro bono. This is something where we refer them to you. Let me know. The only catch there is that you have to be a competent attorney. So check, and you have to do it on a reduced fee basis. But some positives: I don't ask you what your fee is, and I don't tell you what a fee should be. You just have to tell me that it's on a reduced fee basis. So something to think about. If you're interested in anything like that, just reach out to me and I can get you put on our list. I've actually already had one person in attendance reach out, and I love that. So we'll do that. I'll also say that if you were just interested in learning more about becoming a judge advocate, so serving part time or even full time, if you wanted to do active duty, we're more than happy to talk with you about that. Or if you had a paralegal law student who was interested, just send them our way and we'd be happy to talk with them. So our Office of Legal Assistance, I kind of put it in this order. This is just sort of the things we see. It's some overlap from what you've already heard. I think the people reaching out for help all sort of, have some commonalities. A lot of landlord-tenant issues, a lot of, military employment issues. And by that, I mean people having problems with their private employer as they're trying to serve part-time in the National Guard or the reserves. Family law, I put discussions because you'll see at the bottom of the list, we don't litigate. We never enter a court appearance on behalf of someone. At most, for those situations, I might write a strongly worded letter for one of our service members. But a lot of family law discussions, helping people kind of get where they need to get with divorces or child support, and just kind of understanding their left and right limits. Then we do estate planning, but maybe a little bit more limited than what you all do. We've got wills that we'll prepare, powers of attorney, advanced medical directives. We'll all do that. And everything we do is, of course, just for the soldier, free of charge. This is a government benefit for those people who choose to sign up. Some of the things that I don't think I have on here, but I'll point out things we don't help with is really sort of more private employment issues. So, we may have the briefest discussion, but we can't help someone with a Title VII case or an Americans with Disability ADA, FLSA. So those are the things where we really need a good referral list to help out with. And we don't help out with private businesses. Just because you're in the military, you can't use us as your corporate attorney. But even if you've got a client and they got the military connection, feel free to use our services because we can make that easier. We can explain some of the military side of thing. Maybe it's a divorce and you're wondering how military pay works. have them reach out to us, and we can talk with each other and kind of help out the service members as best we can, both sides of this, military and civilian side. Um, yeah, so I'll jump into just a little bit of my discussion. I think I'm going to be short on time, which is perfect for me because I like to blow through my material. Um, so there's a lot of Arkansas specific laws out there relating to employment. Most of them relate to government employment. So the state, state of Arkansas doesn't really love telling people what to do, but they love telling the government what to do. So you'll see a lot of very specific government rules here. There's some that still apply to private. So, the best law out there is USERRA. That's the federal law governing employment and reemployment of service members. But there's quite a few state ones, and I just wanted to go through them, let everyone know they exist, just in case, this issue ever comes up before you. The first one, local officials. So this is actually elected and appointed officials. If somehow you find yourself representing like the governor after someone tried to fire them after they were drafted, just congratulations. I don't know how that happens, but there's a law out there protecting elected and appointed government officials. There's some protection for employees under this law, but it's primarily for those elected and appointed officials. It says that while they're deployed, they're keeping their office and they can run for office, even if they're deployed overseas. As long as they can check all the appropriate boxes, they can run for and be elected while they are, on active duty. The catch here, of course, they can't receive compensation. I'll take just the briefest of moment to tell everyone that if you start doing this type of work, it's awesome. And it's awesome because you get to make the best argument in the world, which is like, oh, hey, judge, do you like the military? Do you love freedom? Well, you should side with me. And you think I'm kidding, but that's how every Supreme Court argument starts when it relates to veterans and military benefits. Every one of them starts with, well, if you want the military to fail judges, you can rule against us. And it's the greatest argument in the world because no one wants to say no to you. But again, that's our special little rule for elected and appointed officials. So there's a special rule for local and state employees. So it says it's for training in emergencies. But if you go and read this law, and I think the citation is in the bottom corner, it's really anytime an employee is in a duty status, whenever they're doing actual military work, they've been ordered to do something. It says training in emergencies, but then like the definition within it is like, or anything else. So what happens is those employees get 15 days leave plus travel time, and it's quote necessary travel time per year. And the 15 days can carry over until the next year. So, you're looking at least 15 days. Usually that's going to be more. What's that should do is cover the annual training requirements for us reservists and National Guard out there who have to do their 2 weeks training a year. So that's really intended to cover that. But again, it can be for virtually any purpose where someone's performing official military duties. You'll see then there's a whole separate benefit just in this statute. I didn't draft it. They put a lot in there. Is 30 days of emergency leave to respond to an emergency event, which is, your disasters, riots, breach of peace. Really, anytime the governor or the president is calling up, the National Guard or the Reserve to respond to something like that, they can get these 30 days paid leave. And again, this is for state employees and then local government. So your municipalities, counties. I think I looked at the statute and it said township employees. There shouldn't be any township employees out there. But if there is a deputy constable listening in, they're protected too. So there's that one. There's going to be some overlap in this. This is my favorite one. So protection of public service. So people engaging in public service. It doesn't say military specifically, but we're pretty sure it counts because it includes any performance of, any duty required by the state. If an elected official infringes on that, they're guilty of malfeasance, which is a misdemeanor, and they can lose their office. So it's criminal. It's criminal. And I just love the threat that like, hey, if some mayor gets it wrong, they get thrown out of office. I've never heard of this happening. I, again, worked at the Arkansas Municipal League for about 7 years with municipal officials. Never once heard of this. It'd make an excellent threat if you're representing a veteran, though. Make a wonderful way to threaten. Um, the state military leave in general looks a lot like that state and local. There's two. The state is mentioned twice. I believe they're identical, but for just a couple of different words if you go and look at the statute. So, won't spend any more time on this. The state employees themselves have two specific statutes, and it's there. So, statewide for private employers, there is actually protection for military service. So it's not as good as those paid leave statutes we just looked at, but we do have one statute on the books, 1262 413, and it protects the employment. It says, hey, you can't fire people just because of their military service. It says you can get attorney's fees if you win the case. The note, of course, is that this is before the big federal law, USERRA, was passed. So it's not as friendly as probably the federal law is, but it's out there and just, want you to be aware of it. It applies to the private employers with 5 or more employees. The one carve out is religious employers. There's a definition out there, and it provides, it's some compensatory damages, but they're capped, cost of litigation and attorney's fees, all the sort of things you would expect. But if you're looking at this, this should only be the throw-in in your lawsuit. You should be probably focusing on the USERRA. It's going to be a better vehicle for you. State employees and school district employees, there's actually an additional compensation law out there. So what this does is try and say, if you're a state employee and you go on active duty orders and it would reduce your salary, well, it's going to try and make that up to you. It's going to try and put your salary while you're deployed where you're not losing anything by serving in the military. School districts is similar. It's a little less beneficial. I won't read it to you, but just know that it's out there to say, hey, we're gonna make this up to you. So I'll talk briefly about USERRA. I'll kind of blow through this just in case there's any questions. But again, it's the Uniformed Services Employment and Reemployment Rights Act, federal law protecting military service. I think that it went through a couple of changes over time, but you really have to look back and see sort of the Vietnam era, where there were employers and honestly other government entities who would say, yeah, no, we don't want to help out with this. We don't want the military. We don't want to encourage that. And in response to that, a lot of these laws got very strong protections for our military service members, especially the part-time ones who have to leave the civilian world to go do this job and then come back. So it is very deferential. It's fee generating. My previous boss would always talk about the worst case he ever lost was a USERRA case, and the facts weren't even that bad. But at the end of the day, for I think a dispatcher ended up, being on the hook for about $250,000. Did a unnamed city in Arkansas that has an Air Force base next to it. Not going to say any more than that, but it was a $250,000 judgment. So these are very real cases, and yeah, no one wants to be mean to veterans, but if you catch them doing it, I would say don't hesitate. No minimum number of employees. So this isn't like, again, all those other discrimination acts. This isn't like Title VII or ADA. It's not 15 or 50 employees. It's just, hey, this applies. This applies. If you have employees, this probably applies to you. It can apply to temporary or sort of, those sometimes employees, those summer lifeguards. They can be, they can get protections under this where they wouldn't under any other law, as long as there's an expectation that the employment will continue. So next summer, I expect to have this exact same job like I have for 5 years. Well, they may be employees under this. State and local government specifically included. I'll add that in 2022, the Supreme Court had a case, and Texas had not accommodated a returning veteran who had a disability incurred in the service. And that's also part of USERRA. You also get some disability protections. And Texas said, hey, we've got sovereign immunity. And the Supreme Court said, absolutely not. You 100% do not have sovereign immunity from this, Texas. So, there's probably a lot of issues out there. Keep an eye out. Don't be intimidated by the government, because I think we always hear the worst infringers of USERRA rights is the government. We just, we're not great at it. So some things, the employee does have to give notice. That's part of it. If they want this protection, you got to give prior notice, except when it's impossible, right? So there are the scenarios in the military where you're not going to be able to give notice. You're going to be told day one, tomorrow you're going to be on a plane. But this is easy. It doesn't even have to be in writing. That's helpful. But they need to give notice. Can be for any federal military duty, entrance exams, training, war, whatever. Um, Main thing, the employees not only get protection from discrimination and their job back, but they get benefits while they're deployed. They get continuous health care coverage, and I may say this later. I'll go ahead and say it now, but it's as if they're still employed. They're still going to get some retirement benefits as this is happening. When they get back, it's going to be as if they were at the company the whole time. So if there's mandatory promotions or cost of living increases, those are things that they are going to probably be eligible for. I think the common analogy is this is like being on an escalator, as you say, or if your job keeps going up along with everyone else's, you don't start back at the bottom of the escalator. When you get back under USERRA from deployment, you're stepping back where you would have been, not where you stepped off. So again, this is a very employee favorable statute out there. So you can only be deployed for up to 5 years. So if you're deployed longer than 5 years, you don't necessarily get your reemployment rights back. But there are certain times that you can see here that doesn't even fall into that, and this doesn't care if it's voluntary or involuntary. USERRA applies to both. So main thing here is that the service, when they get back, it needs to have been honorable or general. So, you've heard some of the other talks earlier from Rebecca, about these different characterizations. They need to have a good characterization. That's the main thing. You don't get to, be terrible while deployed and then get these benefits. We want to encourage people to be on their best behavior in the armed forces. So this is one thing to sort of, ask or get to the bottom of. I'll skip a few to get to the good stuff, just because the wild parts of this is in Arkansas. We're in an at-will state. I don't know other states' laws, but Arkansas, you can be fired at the drop of a hat. Once people return from deployment or from just any sort of active duty service, under USERRA, they actually have special discharge protections. So they can, as long as they're in some sort of military status over 30 days, they become a not at will. They become a for cause employee. The federal law says, Arkansas, you're no longer at will. With this single employee, they are now for cause. You have to have for cause. It depends on how long they were performing that service. If it's over 180 days, they get 1 year of for cause protection. 31 days to 180, they get half a year, 180 days protection. And less than 30 days, they don't get the protection. But heck, not being an at-will employee for half a year is that's fantastic in Arkansas. Previous life, I would tell people to get fired at the drop of a hat. They'd be like, I don't really like this guy. I go, hey, as long as it's not illegal, let him go, just fire him. But couldn't do that under USERRA. Wouldn't be an option. So I won't belabor the point. I think we got 5 minutes left. Again, very beneficial to service members. Take a look at it, even if you don't really do this sort of thing a whole lot. Just sort of read through it, familiarize yourself. Because I just like threatening people as an attorney. Occasionally, I just want to call and just scare some people. So this is an excellent one to do that with. But again, if you have any questions, want to be added to our civilian referral list, questions about becoming a judge advocate or a paralegal for the Army, or again, any branch of service, honestly, just reach out. I'll be happy to discuss it with you about any of those topics or anything we covered today. I'll turn it back over to you.
Thank you so much, Lanny. I don't see any questions in the chat. Go ahead and put your questions if you have any questions for Lanny. Let me throw a question at you. Do interested attorneys need to contact you or your office for the attorney referral program?
It can be either. Just if you've got a good contact here, just let us know. But you can reach out to me, and I'll be happy to get that over to you, kind of show you what it looks like.
And how can a person apply for services with you, at least for the consultation?
Yeah, so we have just a form, and if you know, it's again open to anyone in the military or veterans or dependents, and they just fill it out, and it's 90% of it is just putting in their DoD ID and just their name. Like that's pretty much it, because you know, other than that, as long as they're eligible, we're gonna look at it, and then you know, I'll talk with them. If I can help them, I will, and if I can't, I'll refer them out.
And does the type of discharge matter for those who are applying for service for the service of the consultation?
Yeah, so they'll need to be an eligible retiree. So if it, you know, it's conceivable that if they didn't serve honorably for enough time, they won't fall into that category. But I suspect anyone who has those questions, either you know, they can try and we'll see, or they'll probably know not to.
Perfect. Well, I'll also send your contact information on that same email. That way they can forward any potential clients to you guys. Well, if there are no more questions from the audience, oh, I see there is a comment. Okay, Robert has a comment. Um, he says that was the most streamlined Lucera presentation I have ever seen. Outstanding.
I'll take
Yes,
it.
great job. Well, finally, I just wanted to thank our presenters today for taking the time, and also to thank the audience for participating in the CLE. And I want to invite everybody to donate to our fall fundraiser. I know our fundraiser also helps fund the Center for Arkansas Legal Services and Legal Aid of Arkansas. So please consider donating, and just wishing everyone a happy holiday season. If there are no more questions, we'll end the CLE. Thank you so much, Lanny, Rebecca, Cheyenne. Thank you. Have a beautiful day.